Hey out there, legal warriors. Malicious mischief, quite the name. That's a crime in Washington State. What is malicious mischief? What are the different levels? What do you need to know about it? If you're interested in the criminal law, this thing in general, stay tuned because this is a video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. I'm just going to jump right into it. Malicious mischief. Mal-miss. Okay, that's what we call it in the industry because it's tough to say. Basically, malicious mischief is a crime in Washington State, and it means property damage. Knowingly, intentionally, maliciously damaging property of another is a crime in Washington State. And there's three things that you need to know in this video that I'm going to cover. One is, what are the definitions for malicious mischief, the different levels? Two, what are some really gotcha practice pointers that you wouldn't think about that many people make a mistake about? It's important to know those. And number three is, how might we defend that type of charge if we're facing it, right? So the different levels of malicious mischief. Well, there's one level called malicious mischief in the third degree, and that's a gross misdemeanor. That means damaging property of another knowingly and maliciously, intentionally, with a value of less than $750. So if something is broken and its basically replacement value is less than $750, that's not a felony. It's a gross misdemeanor with a $5,000 fine and 1 year in jail max. The statute also says basically tagging anything that's not your property, graffiti, because that may not be, it's not always clear if that was damaged or not, because maybe it can be taken off. Well, tagging something is also malicious mischief in the third degree. Unless there's damage more than $750, then it moves up to a felony. Malicious mischief in the second degree means the damaging of property and knowing, intentionally, maliciously, that is $750 up to $5,000. So if it's between $750 and $5,000, then that's going to be a Class C felony with a $5,000, not a $5,000 fine, but 5 years in jail maximum. Okay, 5 years in jail maximum, although there's going to be a standard range sentence. It's going to be less than that. A felony means you're going to lose your right to possess guns, lose your right to vote, so it's very serious. You can also, if you substantially impair the ability of an emergency vehicle to operate, or substantially impair a voting box, that can be a malicious mischief second degree. I've never seen that charge, but it's in the statute. And finally, malicious mischief in the first degree means basically more than $5,000, okay, of damage, and that's going to be a Class B felony, 10 years in jail max. There's also going to be a standard range sentence, much less than that, but again, the voting rights, and you're a felon, gun rights, you'd lose all of that. So those are sort of the categories of malicious mischief, and you can also have malicious mischief domestic violence. Remember, if you've seen our other videos, domestic violence is not an actual statutory crime. It's a designator tacked on to other crimes. So if the property that gets damaged of somebody's, if you take your brother's iPhone and smash it, well, that's malicious mischief domestic violence because of the relationship between the defendant and the victim. In this case, I called the victim a brother. Okay, so if it's a domestic violence designator, that gives the court more jurisdiction, but it's not going to change much else. It gives more probation time to the court, but it's not going to change much else in a malicious mischief charge. So what, number two, what's sort of the gotcha things to know about? Well, the biggest thing that people mess up and get charged with is they break what they think is their own property and say, I'm allowed to break my own property. Well, that's true if it's totally your own property. If you're a single person and you take your own phone and smash it onto the ground in anger, well, that's your phone, you own it. That's not property of another under the statute, and therefore you can do that. Where the problem comes is if you're married. If you're married, Washington State is a community property state, so the default is everything that somebody acquired during the marriage is half theirs and half their spouse's. So gentlemen, that dress that you bought your wife that you're never going to wear, probably, maybe you will, but if it is not 100% hers, that's also half yours. If she destroys that dress in anger, it's her dress. No, it's half yours. That's property of another. That'd be malicious mischief. So if you break property, a plate, hey, I can break my own plate. It's my own house. How could the police arrest me for breaking my own plate? Well, if that plate was acquired during the marriage, the default is community property. That's half the spouse's. You broke property of another. You're guilty of malicious mischief, domestic violence. And so if you're in a situation where you're feeling like you want to break some property, it's probably best to just throw a pillow, right? Don't break the property, and don't throw the pillow at your loved one, because that could be assault. So another gotcha is, punching a hole in the wall. Well, unless if you're leasing that place, you don't own it, you've damaged the property of another, whoever owns that property. If you acquired the home during marriage, it's half of each of yours, right? And if you acquired the home before marriage, if there's a mortgage, it gets complicated. So, these things about damaging your own property, it's rarely your own property unless you're a single person and you own it outright. Then it's yours. Break it if you want. So that's the second thing. The third thing is, how do we defend these things, right? How do we defend this and get you out of this trouble? And there's two sort of categories here of defenses, okay? The first would be malicious mischief charges that we can defend through something called compromise of a misdemeanor. And then the other category is the ones that we can't defend through compromise of a misdemeanor. What is compromise of a misdemeanor? Well, we've got a video on it. Hopefully my team will link to it, or maybe they'll put something up here where you can look at it. Compromise of a misdemeanor is a statute that says if a victim has a civil cause of action for a crime that can be satisfied by money damages, then if those damages are paid and the victim signs off saying I've been paid, the court then can dismiss the case in its discretion for a non-felony, so it's malicious mischief, third degree. And this compromise of misdemeanor statute also says it can't be a domestic violence case, so it doesn't work in mal-mis DV, and a good number of the malicious mischiefs are DV. When would it work? Well, a straight malicious mischief third degree, where you break out the window of your neighbor's house, or you get into a fight and tear someone's clothing, or you purposely bash in a mailbox, and all these dumb things we could do when we're angry. But in those cases, if the victim isn't related to you, that's not a DV case, we pay them for the damages. If they sign off saying they've been paid, we can ask the court to dismiss your case. So that's a great way to get a malicious mischief case dismissed. Well, what about cases where that's not going to work? Either that's a DV case or a felony. You can't use compromise of a misdemeanor and felonies. Makes sense because of the name, right? So in those other cases, what you're looking to do is defend in different ways. One way is to claim accident. I didn't purposefully break the property. It was an accident. I dropped the dish on accident. I didn't drop it in anger. I've seen those cases with the door. Hey, this door slammed as it went out and it came off the hinges or glass broke, but I didn't intend that. I didn't even intend to slam the door, okay? That could be an argument that there was no maliciousness to the destruction of the property. Another argument could be that the property wasn't damaged, right? Hey, the air got let out of the tires, but were the tires really damaged? That's a case we see quite a bit, where someone gets mad and lets air out of the tires, and we have an argument about is that damage or not, okay? And finally, we could also say that the property wasn't theirs. That was my property. I've had that case. Okay, years ago, I've had a case where it's like, hey, the couple was married, but I could finally get proof that the phone was acquired prior to marriage. The phone was not commingled. The phone is itself. It didn't get commingled as community property like money does, or a bunch of M&Ms would, right? And so that maintained that person's own individual property, and therefore damaging it was not illegal. But we had to come up with more stuff to show that, and then clearly it didn't fit under the statute. Let's finally say, though all those things don't work, how do we defend? We defend in the normal way, right? We defend by getting the client to maybe do an anger management class, finding out, trying to compensate the alleged victim for the damage, pointing out to the prosecutor all the good things we've done since, maybe we have no record, and trying to get the prosecutor to let us go by trying to make it right, getting some education, and hopefully pointing out that we don't want a person's life ruined over some property damage, especially if they sort of pay for the property they damaged. So, that's malicious mischief. And if you get a malicious mischief felony, then we're trying to get them down to non-felonies. There could be alternative felony prosecution programs. I've had felony malicious mischief go into things like TAP, therapeutic alternative to prosecution, that's in Snohomish County. There's not necessarily adult diversion in every felony court, but sometimes in a felony court, if we can show that the damage was caused by drug or alcohol use or mental health issues, maybe we can get treatment for those things in lieu of being prosecuted, as long as we pay for the damages. So if you're charged with malicious mischief, take it seriously, get a lawyer. But as you might guess, property damage for the most part is looked at a little less intensely than crimes against people directly, right? So if you find this useful, please like and please subscribe. More people will get the help they need. And more importantly, if you need some help, feel free to reach out to my firm. Give us a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.